apology. I'm going to ask for some assistance in terms of the agenda from the parliamentary support, because I'm driving and probably won't get to office in 10 minutes. But can we, in keeping with the agenda, are there any apologies for absence? Anyone? No? Okay. If there are no apologies, then the minutes are or should be before us. Can we review so we can get to matters arising if necessary?
Yes, Mr. Chairman, good morning. As we go through the minutes, I'd just like to make a note that there seems to have been an error. I had indicated in the last meeting an apology for Dr. Guy, who had indicated he would be late, but then ended up not making the meeting. So if we could just make that correction.
Okay. We'll make that correction. I'm gonna ask it's a little awkward, and I apologize for this, but because I am actually driving, I was wondering if I could ask or someone to lead on the minutes page by page, and then so that we can go through in the meantime. Can I ask Madam H, would you do me the honors, if you don't mind?
Sorry, Minister,
to just go through the minutes page by page on my behalf.
Can I ask the staff to just bring it up on the screen for me? Just give me 1 minute, Minister. The connection is a little patchy. Just 1 moment.
Are we able to do that? Okay, great.
I just shared the screen. Is anyone seeing it?
Yes, I'm seeing it.
Okay. So maybe if AG, you would be able to, can you see it? Is that good?
Thank you so much. Thank you so much. Meeting was called to order at 10:14 a.m. Prayer by Mr. Albert Edwards. Apologies tendered on behalf of Senator Longmore, yours truly, and MP Lee. Chairman.
Welcome and open remarks. Let's move to the next page.
So is there any correction in respect of this page, page 1?
Right, so we'll just go through page by page.
Okay, so that's the page I'm asking for the minutes to reflect that I had apologized on behalf of Dr. Guy.
Yes, okay.
And Chair, also, good morning, everyone. If it could also reflect that my apologies were for being late, not absent, because I was actually at the meeting subsequently.
And so was I actually. Yes, I came late too, if I am recalling. Yes.
Senator Longmore, it did say lateness for you.
I look back on my schedule. All right, thank you. So,
okay.
Senator Longmore, what you're asking to be corrected has been reflected. Apologies.
Okay, fantastic.
Member
Thank
Guy.
you.
Yes, page 2, so we can accept page 1, page 2. Chairman told members that join a little down, please.
is appointed to consider. You've gone too far, Senator Allen. The committee to consider and report on the bill.
Madam AG.
This is the National ID and Registration Act. That wouldn't be it.
Madam AG.
Yes, I don't go through it.
Might I suggest that having regard to the fact that most members would have read the minutes, you could just indicate the respective pages and for the corrections to be there, if you so desire.
Yes, I didn't intend to read it verbatim, Member Guy. That would be way too time consuming.
Right. Page 2 is before us. Any correction? If none, then we can adopt and go to page 3.
Yes, page 4. Right, we can go to 5. Page 5, could you bring all of page 5 up? Thank you. Page 6. Senator Allen, would you bring up page 6, please?
I'm on
Right.
page 6. Yes.
Yes, yes. Thank you. If there are no corrections to page 6, we'll move to page 7.
Page 6 is still. Thank you.
If there are no corrections to page 7, we move to page 8. Page 9, no corrections to page 8. We move to page 9. Thank you. So in respect to the corrections to this page, Madam Recording Secretary, please note in respect of page 1 that I did come in late for this meeting, right? Not that I was absent.
Thank you. There be no other corrections to the minutes. We could move for confirmation. Member Guy?
Madam AG, having regard to the fact I was at the meeting.
Oh, you were not?
I see. No, got you. Yes. All right.
Madam AG, I'm so moved that the minutes be accepted.
Seconded.
Thank you, Senators Campbell, Golding Campbell, and Allen. Confirmed and seconded. Chairman, Minister.
Seconded by Dr. Longmore, actually.
Oh, it's Dr. Longmore, I see.
Yes.
Very well. Thank you both.
Our voices clearly sound similar.
Well, I thought it was Senator Shireen Golding Campbell, but.
Yes, it was her who moved for it and seconded by Dr.
Oh, I see. I see. You weren't the one who seconded. Thank you for that correction, Senator Allen.
All right. I believe the next agenda item would be matters arising.
Madam AG.
Yes.
I just want to indicate I had committed to submitting questions to the committee on the last occasion. I am still formulating those questions, so I respectfully ask for a little bit more time.
So we will record that the submission of questions by Senator Golding Campbell be deferred to another sitting to allow her time to complete her formulation of those questions.
Madam AG,
Yes.
are the questions, and I'm asking through you to Senator Campbell, are those questions related to the bill itself or to the actual minutes? Because there will be an opportunity when the committee goes clause by clause to have certain look at some of the concerns that the committee members.
My understanding, Senator Golding can clarify, but she did say she had previously indicated. Senator Golding?
Yes, the questions are related to the clauses in the bill, and it's not. I'm not anticipating that they're going to be necessarily addressed at this time, but in the interest of time and efficiency, I thought it best probably just to submit them, and we can deal with them at the clause by clause stage of the committee.
Madam Chair.
Yes.
I have a matter arising on page 4. And just
Senator Allen, we're going to ask you again for your kind indulgence is to bring back page 4 on the screen, please. Page 4 of the minutes.
Well, while she does, it's just basically to ask the consultant, Mr. Edwards, the matter as it relates to children and the workplace and children. What is the age group that has been used in this legislation? Or probably you could answer, Madam AG, for children.
Well, a child in law has a definition.
Mm-hmm.
Children of tender years. Mr. Edwards, would you want to assist in responding to that question from Member Guy, please?
Yes, Madam AG. In fact, as you were leading to AG, the child reference is to anybody under the age of 18 years.
Oh,
so
yes.
that's the context.
Just to say that as a general rule, we have standardized that reference. Any reference in legislation to a child is a reference to a person under the age of 18. We may have
other categories of children below that or other thresholds, but as a general rule, that is where it stands in our laws. We did that standardization many years ago when we passed the Child Care and Protection Act and did some consequential amendment. But of course, different provisions may target children at lower ages for particular reason.
So the minutes reflect, Mr. Edwards, your presentation that the regulations make provision primarily for matters relating to the workplace and children.
There's another matter, Madam Chair, at page 7. Just a question I'd like to ask, but probably will come out more in the mix. The proposed legislation in terms of packaging seeks to move the surface area of packaging from 60 to 80%. any particular reason why this is so? Is it a mandate of the WHO framework for tobacco control? And secondly, what is the prevailing standards in other jurisdictions?
If I may.
Senator Allen, just bring up that last paragraph where they advise that the requirements. Thank you so much. Mr. Edwards, please.
Thank you, Madam Chair. So the increase in surface coverage for the labeling, the warnings, is consistent with our commitments internationally. And I'm going to invite my colleague, Mrs. Cheryl Dennis-Wright, legal counsel in the ministry, to further elaborate on the comparative approaches in relation to labeling. But it is
just before she comes in, perhaps it may be useful to contextualize that the preferred position is that of prohibiting consumption of tobacco because of the harmful effects. Sometimes warnings are written
in the smallest of language just to satisfy a requirement, and persons who are consuming or interacting with the good can barely see it. What's so important is the
You're losing your chair.
Madam AG,
Yeah.
we're not hearing you at all. We're hearing you now.
Hearing me?
No, yes.
Are you hearing me better now?
Yes.
I see. Right. So just to look at the note that is indicated that it was required according to the provisions of the bill that 80% of the surface area of the product
must indicate health warnings on.
You're going again, Madam AG. Something is wrong with your signal.
Yes. Better now?
No, it's still low.
Let me see if I can deal with the volume, but if you are hearing, just to indicate that insofar as the size of warnings or the warning labels are concerned, is to ensure that those warnings cannot be missed because of the high health risks that are involved in consuming the product. Mr. Edwards, your team member may pick up from there.
Well, I may, thank you, Chair AG. I would assist further by indicating specifically the comparative approaches, because that was also one of the questions. Now, at least globally, at least 114 countries have adopted the approach whereby the pictorial warnings cover 50% or more. Now, some go even beyond 80%. So, for instance, we'll find that India is at the 85% level, Australia is 82.5%, Sri Lanka and Uruguay 80%. Several countries in Africa are between 70 and 75%. In Canada, they had increased the pictorial health warnings from 50% to 75%. So, and I should also indicate that there are some countries that go as far as 90%, Nepal and Vanuatu being examples of this. The purpose of the increase in size of the health warnings is not just as significant as it is to indicate the health dangers of smoking, but also to reduce the opportunity for the packaging to be used for promotional aspects, for promotional purposes. So there are two reasons why the larger the size of the warning, it creates a greater impact in terms of the health dangers, but it also reduces the opportunity for the very packaging to be used for promotional purposes.
So my question, Mr. Edwards, is it that the WHO the FTCT guidelines say more than 50%. That's what I'm asking. What did it actually say to have this variation, or in the terms of the different jurisdiction having different numbers?
Okay, it didn't say that. Is my colleague Mrs. Dennis right, Cheryl?
Yes, I'm here. Good morning, everyone. No, the guidelines, and certainly at the conference of the parties where these guidelines are reinforced and have been adopted, actually recognize, I believe they started out at least 30%. However, based on the evidence over time, it has recognized that the principle that bigger is better is actually scientifically based. And therefore, that is the reason several countries, including those that Mr. Edwards had just indicated, have actually moved to implement graphic health warnings that are so big. And he would have cited some of the countries already which have gone over 70%, some even up to 90, as he said. We have also seen a trend where countries are not only moving to bigger health warnings, but they are actually going into plain packaging. And plain packaging really means that they are essentially removing, the graphic. They are removing the labels that these companies would put on the products. And I would hasten to say that there has been several legal victories worldwide that has shown that where there has been a challenge that is brought by the tobacco industry or by a tobacco country in a particular jurisdiction, these challenges are usually struck down in favor of public health. So I believe that we're on safe grounds as it relates to increasing the graphic health warnings. We are not going as far as plain packaging at this point. However, we are on solid footing. Even up to the level of the WTO, the World Trade Organization, we have seen a recent victory in the case of Australia, where the panel ruled in favor of public health, including plain packaging, which they have implemented.
If I may continue more specifically to respond to the question, thank you, Cheryl, to respond to the question as to the actual requirements. The FTCT does not specify a percentage of the packaging. The FCTC obligations are that parties ensure that the warning, that the tobacco product packaging and labeling carry large, clear, visible, and legible health warnings. So to answer specifically, Member Guy, the international obligation is not specifying a numerical coverage in terms of the size of the warning, but it is speaking to large and visible, clear, and legible health warnings. And
okay,
yeah.
Okay, ladies and gentlemen, first of all, again, my apologies for the record for have you waiting. I don't know why I thought I needed to go to Parliament, but I'm back. Thank you, Madam AG, for just leading the proceedings up to this point. I really want to get to the next phase of the presentation by Mr. Edwards. And so we are, I think the point is made in terms of Member Guy's question about the warning on the packaging. So we probably can elaborate more on it as you make your presentation, Mr. Edwards. If that is good, are there any other matters arising from the minutes?
Page 8, Chairman. Mr. Edwards, you sought to give an explanation in relation to a question raised by Senator Golden Campbell about persons who will have possibly a conflict of interests if they are invested in any matter related to the tobacco trade or any company that has interest in the tobacco industry. Now, the legislation, as far as I see, spoke to public body. And the question I want to ask here, members of parliament and others would be persons who are employed to public bodies. Isn't that so? And if the answer to that is then the affirmative, are you therefore saying that any person who works in the government sector, because this is exactly what the minutes is reflecting, anybody who works in the government sector would be required to divest themselves of those investments. And secondly, any person who is seeking to get a job in any government sector would be required to declare their interests in any undertaking related to the tobacco industry. Isn't this a bit too intrusive in the rights of a particular individual? I have a concern about that. And the matter is, what about industries or companies, for example, that may be also in the tobacco industry and have interest in other areas of the economy that you are invested in as well? Though it's not the case now, but what comes to mind readily is when Carreras, as it was then, was invested in the hotel industry. And how do we reconcile this diversity of operations if that were to be the case?
Chairman, if I may, I'm wondering if some of the concerns of Member Guy are more related to the aspect of the joint select when we go through the clause by clause. I understand that it relates to the minutes, yes, but you know, Mr. Edwards has not completed his presentation as yet, and I think the level of discourse that might be involved might require the rest of our participation. And considering where we are in this meeting now, perhaps we should, you know, keep on track and allow Mr. Edwards to complete his initial presentation. And then some of these issues will be thoroughly teased out when we reach to the presentations from the submissions and the clause by clause.
I think, I think that's a useful intervention, Senator Longmore. I do appreciate the question. I think it's an important one. Mr. Edwards, if you can cover that more substantially in the presentation, maybe you could just indicate the case, that is the case, and then we can move on. And that's the approach that we have taken in these committees, where we raise matters that we don't think will be addressed otherwise in the substantial presentations. So, Mr. Edwards, is that an issue that you'd be able to address?
I don't have a problem with that.
Okay, thank you very much. So are there any other matters that will not likely come up in the rest of the presentation by Mr. Edwards? Anyone wants to raise? If not, I'm going to ask Mr. Edwards to begin to complete his presentation. Remind us where we left off, and then go into the next phase, please.
Okay, so where we are at now is actually, we had closed off on that issue of clause 8, which dealt with that very issue of the conflict of interest and transparency of interactions between public officials and the tobacco industry. So I am going to begin my screen share. If you can just give me a second, thank you.
So while Mr. Edwards is doing that, can I just ask that we mute our mics if we're not speaking? I think there's some background noise coming through.
So sorry, members. I'm just bringing up the document. Okay, I hope my screen is now being seen.
Yes.
Oh, thank you. Okay, so the very point that member Guy has been has led the discussion on is where we were closing off, where we closed off at the last sitting. We spoke of the guidelines for the implementation of Article 5.3, and this article is the one that relates to engagement between the public bodies, public officials, and the tobacco industry. Let's see. I'm having a little difficulty with my presentation here. Okay, so the guidelines in relation to the implementation of Article 5.3 indicate that they're applicable to government officials, representatives of national, state, provincial, municipal, local, or other similar institutions. Any government branch responsible for setting and implementing tobacco control policies would be subject to the guidelines in relation to restriction on interaction and investment in the tobacco industry. The principle being that there is an irreconcilable conflict from the perspective of those who are seeking to control the use of tobacco. There is an irreconcilable conflict. That's a philosophy, that's a policy underlying these controls. One, fundamental and irreconcilable conflict between the interests of the tobacco industry and public health policy. Secondly, that parties, states parties, or parties at the local level, when dealing with the tobacco industry or working to further the interests of the tobacco industry, should be accountable and transparent. So in other words, there should not be secret meetings, secret deals. Everything should be above board, because of course, there will have to be interaction between the public bodies, public officials involved in public health matters and the industry, as with any other industry that touches on concerns, matters relating to health. So the direction is that there should be accountability and transparency in those dealings. And finally, principle 3 is related to principle 2. Principle 4 is that because the public health perspective on tobacco is that the product itself is one that has potentially a lethal effect, that the tobacco industry itself should not be granted incentives to establish or run the business. So let me just go back. So that is where we had left off last week. This is clause 8 and 9. Clauses 8 and 9 of the bill are where we find the provisions relating to managing interactions, managing conflicts of interest, between the tobacco industry and the public officials.
Through you, Chairman. Thank you. Through you, Chairman, Minister Tufton. It perhaps would be interesting, in light of Member Guy's question, to just hear whether he, where he stands in respect of these guiding principles as a medical practitioner and member of the committee. My own curiosity, but also just understanding where we as legislators stand in the acceptance of the principles and the expert advice which provide guidance to us.
Member Guy?
Member Guy, need to unmute.
Yeah. I'm sorry. I was saying, Madam AG and Chairman, as much as I understand what is the FCTC is saying in terms of the guidelines, and as much as I am as a medical practitioner understand the ills of smoking and the whole aspect of what it can cause and its impact on the health and the economy of the country, the challenge I have is are we, Mr. Edwards, bound to accept this particular guideline? Because it is going to be one that creates a lot of challenge for members of the legislature, members who have interests elsewhere. I mean, I don't have, and I'm first upfront declaring that I don't have any interest in the tobacco industry, but there are others who do and others who may have, right? And my concern is that, is this not an intrusion on the rights of an individual to have such a legislation being enacted?
Through you, Chair, the truth is that it is in fact intrusive, if that is the appropriate word, and deliberately so, because the whole thinking is that, especially in relation to public officials or public agencies that have direct responsibility for matters of policy in relation to health, and more specifically public health, it is a direct restriction, prohibition, control, because of the fact that if allowance is given for interaction at a certain level between such officials and industry players, there is the possibility of compromise in terms of policy development, in terms of enforcement, in terms of administration. So it is deliberately an intervention and intrusion, so to speak, but for a higher purpose, being the health and welfare of the nation.
Chairman, if I just weigh in on this. I think as lawmakers, we are going to be called on to make tough calls. Goal is not always easy. We have to balance competing interests, conflicting interests. And so, especially in the area of public health, sometimes it's just difficult. Personally speaking, while I understand what some may briefly refer to as the vices, the more informed we become, I feel there is almost an obligation to ensure that we present healthy choices to our people. And I'm speaking entirely for myself. No, when I look at Principle 4 on a product being lethal, it does beg the question as to why would we encourage consumption of a product that is proven to be lethal and deadly.
And this is the fundamental, I think, difference, if I may, with this industry as opposed to others. I think when we would have come to the presentations around tobacco consumption and its harmful effects, it will become very clear that the consumption of tobacco is undoubtedly and incontrovertibly a danger to public health in almost every way possible. I think it's important that the legislation recognizes that, advocates that reality, so consumers are kept informed, and indeed discourages any activity that could send mixed signals, if you will, around the harmful effects. And I think that's what this aspect of the legislation is intended to achieve. Mr. Edwards, is this unique to us here in Jamaica, or is this this clause or this principle of irreconcilable conflict standard in the legislation globally?
Chairman, if I may just intervene just before Mr. Edwards respond. Firstly, to indicate that I will have to step out briefly to go into a meeting with the Prime Minister, but will rejoin as soon as I can. But before I go, just to ask whether there is any dispute in respect of the underlying guiding principles, and what would be the basis of dispute. I can appreciate concerns because, of course, we do not exist in a vacuum. And Minister Guy is right that there are commercial interests that are involved. There are industry interests that are involved. But perhaps, to help sequence the discussion, is there any of the underlying scientific principles that would guide the policy of the government in this matter that is being refuted and contradicted? I'm sorry I won't hear the response, Member Guy, because I really have to step out, or I just...
The Minister will record it, Madam AG, but
Yes.
if I may, Chairman, two things. One, Mr. Edwards has not finished answering my question as to whether it is mandatory for us to do. And secondly, in response to the AG's comments just now, there are many other things separate and outside of those industries that the Minister alluded to a while ago, that there are overriding health concerns about that are still not unlawful or any legislation there to deal with them just yet.
But we have to take them in stride, even if all can't be dealt with at the same time. So just to say that the argument that because others exist,
No, Madam Chair, Madam
would
H,
be a good argument.
you
Yes.
are misinterpreting the point as made.
I don't wish to misinterpret it. Please clarify.
Right? All I'm saying is that the matter that is before us, and I was just only referencing what the chairman said, that there are other industries, right, when I made that argument. The point I want to make generally is, does this particular aspect of it, Mr. Edwards, is it at variance with Chapter 3 of the Constitution in terms of its provisions?
Okay. All right, member, let's have Mr. Edwards respond. Mr. Edwards?
All right, thank you. I'm not aware of constitutional challenges to similar provisions elsewhere, because of course we are just seeking to implement this. And therefore I am not, well, maybe I should ask Member Guy the specific constitutional.
I don't have any, but I know the Charter of Rights guarantees certain freedoms and I want to know if in crafting the legislation that there was research done to ensure that there's no conflict of interest with the Charter of Rights. That's all my question is.
Well, in preparing our legislation in our system, we go through that rigorous examination led by the Attorney General's chambers, who seeks to sign off before we even reach a stage of tabling as to the constitution, the legality and the constitutionality more fundamentally of our legislation.
Which is why I didn't want AG to go.
Minister, Member Guy, just to help out, Mr. Edwards, you are absolutely correct that any law that seeks to engage a right has to be approached in a particular way. And so not just this regulation, but all. We are still in the new era of the new charter, and we're learning quite a bit. We are taking care to ensure that one's rights are engaged in a direct way, or even an indirect way, that we go through the constitutional guidance provided by the courts, and absolutely that we have regard to what we provide. Just to say, though, that there is no right to smoking and the consumption of toxic or lethal substance that is guaranteed, if I were to take it to almost an extreme and absurd level. So we have rights as guaranteed. There is no right to smoking. There is no right to consuming or any other way.
As I say, as you are, I agree with you.
So, Chairman, please excuse me. I will rejoin soonest.
Mr. Chairman, if I might interject at this point, because I think I understand the concern that Member Guy has expressed. But if I could just go back to the principle in relation to what we're trying to capture. And my understanding is that we are trying to capture the commitment made in the WHO Framework Convention on Tobacco Control. Article 5.3 is the article that I believe Mr. Edwards referred to. And if I could just be permitted to read Article 5.3, very brief. It says, in setting and implementing their public health policies with respect to tobacco control, parties shall act to protect these policies from commercial and other vested interests of the tobacco industry in accordance with national law. Mr. Edwards, I'm correct in that article, yes?
Yes, okay. Senator Campbell.
Okay, so it is a very broad statement, and it really gives a lot of room in terms of how we interpret that, and what we decide is our policy position in terms of public employees who are interacting with the tobacco industry. The Clause 8 and Clause 9 capturing our policy position. Clause 8 prohibits a person acting on behalf of or for the benefit of a public body with responsibility for tobacco control from interacting in any manner whatsoever with a person in the tobacco industry in furtherance of a business activity. Now, my concern, Chair, is that is such a broad capture, and it touches and concerns the issue raised by Member Guy in relation to the right of a person to pursue an activity. Because a person in the tobacco industry, I am not seeing where that is defined. Who is a person? So if I engage in a restaurant activity with an accountant who works in the tobacco industry, I'm prohibited from doing so. It seems to me that in trying to draft a provision to fulfill our obligations for Article 5.3, that in Clause 8, certainly we may have gone a bit too far, because I think in Clause 9, which discusses
it's even worse.
Well, actually, I believe in Clause 9, what we have been able to do, I think successfully, is to define what those interactions are contemplated. But the breadth of Clause 8 captures interactions that I don't think, from a policy perspective, based on what Mr. Edwards is explaining, we intended to capture. And so that clause, in my view, would require some work in terms of fulfilling the obligation under Article 5.3. And it's not, and I do recognize that we are not bound to the Article 5.3 is so broad that we have quite a bit of room to determine what our particular national policy is. But if I understand the position correctly, that policy is in relation to how we protect, how we ensure that our policy and our laws in relation to tobacco control are not circumvented, are not, and the tobacco industry does not wield any influence over the public officers who have decision-making capacity in those particular areas. Clause 8 captures everybody. Anybody who is part of the tobacco industry.
Mr. Edwards, if I may, last week when we raised the point, you had indicated that you would propose with some greater clarity the specifics of what is intended, as opposed to making it so general that it can be interpreted to the extreme where it becomes a difficulty. One of the things that we have to be careful of is that we do not provide further for those who may want to identify weaknesses just to suit a particular end. And I'm not speaking to us here. Clearly, we are here to probe as best as possible to strengthen the legislation. And therefore, there may be a need for us to define in a more narrow way what the end game is, the end result, what we're trying to achieve, and then using that, therefore, to define more specifically what we mean when we speak to the conflict of interest.
Chair, if I may.
Yes, go ahead, please.
Yes, so I put Article 5.3 on the screen, and thank Senator Golden Campbell for having restated it for us. So Article 5.3, and this is in specific response to Member Guy. The article is a requirement. It's one of the fundamental provisions of the Framework Convention. If we recall that what we are doing by virtue of seeking to enact comprehensive legislation, we're moving from the basic coverage of demand reduction from the perspective of putting up no smoking signs, dealing with labeling issues and disclosure issues, to going to now look at more fundamental issues such as management of policy, management of supply, illicit trade, and those factors, advertising, and so on. So we, in this comprehensive legislation, we did anticipate that we would be getting into some of the more thorny areas beyond the regulations which have served a useful purpose over the last 8 years. So in relation to Article 5.3, the obligation is, in fact, to require that the public health policies are separated and protected in terms of their development and maintenance and enforcement, are separated from the interests of the tobacco industry. And states are actually urged not only to implement provisions that would seek to give this article life, but also to even go beyond. So even as members have observed the breadth of Clause 8, states are even urged to go, if they wish, beyond what our Clause 8 states. No, the concern about the breadth of the language may be addressed to some extent by the fact that there are, and it may not be immediately apparent, there are some qualifications to how Clause 8 is to be applied. One, the term tobacco industry as members would be aware, is a defined term. Page 8 of the bill defines tobacco industry to mean tobacco manufacturers, wholesale distributors, importers, and exporters. So when we speak of the interaction in Clause 8, when Clause 8 speaks of interaction with a person in the industry in furtherance of a business activity, we're speaking of persons who are directly involved as either manufacturers, distributors, importers, or exporters, not the person involved in retail trade directly. We're speaking about the higher level players of industry. Secondly, Clause 8 speaks to persons, and this also is a matter that the policy of the ministry would have, and a minister can elaborate on this, but the Ministry of Health and Wellness would not have minded going beyond what is even stated here, because the policy encouraged by the WHO is to go beyond just persons who are acting in a capacity of tobacco control activity to the broader public sector official. But as it is now, Clause 8 applies only to persons who are involved and who have responsibility for tobacco control activities. So I just wanted to put those qualifications. One, that when we speak about interactions with industry, we're speaking about the high level interaction. And two, interaction with those involved in wholesaling, manufacturing, exporting, importing. Secondly, when we're speaking about the application to public officers, it is public officers who act for a body that has responsibility for tobacco control, which is actually a relatively small number of agencies.
Yeah,
I'm so sorry. Can I cut Mr. Edwards a bit?
Chairman.
Because I think he's misunderstanding the point that I was making, in the sense that the concern is not so much who in the public, who as a public officer we're trying to place an obligation on, and it's not in relation to the tobacco industry defined as manufacturers and wholesalers. The difficulty here is that we are seeking to limit the interaction of that public officer who is responsible for tobacco control with any person, a person in the tobacco industry. And a person in the tobacco industry is not qualified by a person responsible for decision making in the tobacco industry. It's simply a person who works in the tobacco industry for a manufacturer, wholesaler, importer, or an exporter. And
but
so,
isn't it? But
if I may,
and so the absurdity of limiting the interaction between that responsible public officer and, let us say, a sanitation worker in the tobacco industry is captured by this clause. That's the concern.
Remember, is NITDO hinged on the extent to which that interaction is likely to influence decisions around the tobacco industry? I thought that was what Mr. Edwards was saying. Mr. Edwards? And I have a few other persons who want to comment. So after you, Mr. Edwards, I'm going to ask Senator Longmore, then Senator Allen, and then go to Senator Cavan Gale.
Chairman, you seem to have a long time.
Yes, and then member guy. Go ahead, Mr. Edwards, quickly.
Yeah, thank you, Chair. And I should indicate that my initial response was to member guy's original question. So Senator Golden Campbell, I respect the position that you have and the concerns that you have. But the interaction with the tobacco industry is interaction in furtherance of a business interest. So it is commercial interaction. So that's another qualification. It is interaction with a person in furtherance of a business activity. And the
But it doesn't
restriction is
qualify
that
business activity, Mr. Edwards. That's not qualified. So it could be any business activity.
I agree with Senator Golding.
That's the difficulty I'm having.
Yes, it's not qualified appropriately for there to be no misinterpretation. And I know I'm getting ahead of Senator Longmore. I'm sorry about that.
No
but
problem. Go ahead, Senator.
Yeah, while I understand Mr. Edwards's position, it is too unclear, the definitions, and as such it is causing and has the potential to cause misunderstanding or misinterpretation, because it is indeed very broad. And I believe last time when we met, when it was initially raised, the response that was given at the time almost helped to allay the concerns, because it was defined as persons directly involved in the tobacco control. But then when it's looked at within the broad picture with everything else, the definition of who is the person in the industry is causing for there to be some inconsistency with what I believe you are intending. So I think we just need to tighten the definitions in order for there to be no misinterpretation of what is intended.
I fully accept that there can be room for tightening, but I think what the policy officials may wish to hear from committee members is where are the actual areas of grayness, so to speak.
Chair.
Mr. Edwards, just hold a bit. If we're on the same point, I'm going to ask Senator Longmore and then Gail and then Guy to come in, one after the other, and then Mr. Edwards, we can respond. Senator Longmore.
Thank you, Chair. Okay, so just backtracking a bit, because I actually had my hand up from AG had asked a question with respect to the medical perspective. So one of the tenets of our practice is that first do no harm. And that in essence, I think is what obtains in the policy direction to have this inclusion of this restriction of the public body and employers thereof being involved in an industry that just by the nature of the graphic warnings, you see what the subsequent consequence is and the subsequent later burden on the same health sector in terms of care of those persons who suffer the consequences of this consumption. So I think the need is clear that we need to have this level of protection there. Now, this is why I asked whether or not we are going through a clause by clause analysis at this point in time, because the similar concern that is raised by Senator Golden, I raised it in the submission through the JPA. At clause 9, where it specifically states a person employed generally with a public body, but again at clause 10.3, where you have a person who seeks employment with a public body, our concern is that at what levels? And again, I emphasize the point that, you know, it as has been made by Senators Golden and agreed by Senator Allen, that it needs to be more specific. If you have someone who is a janitor, someone who is a non-influential person on the direction of the tobacco industry business, this person is now being restricted from investing in the stock market if they so decide. That may benefit them in another way when they have absolutely no influence on the direction of the industry. And again, likewise at 10.3, where someone is seeking employment, if someone is seeking employment as a chef in a kitchen, he now is being restricted. So I think that we definitely need to have the inclusion of it, but there needs to be a specific limitation and restriction as to the levels as to what you're referring to. Thank you.
Okay, let me get Senator Gail and then Guy quickly. And then I let me just say, members, that it is a little clumsy, to be totally frank, having this session by Zoom. I'm still trying to come to terms with it. I would have much preferred a face-to-face, but so it's a little more difficult to control. I do agree with the suggestion that perhaps Mr. Edwards should go through the entire bill, and then we make our points and argue at that stage, because the one clause is connected to the other, and we have to now go back and forth if we query too much clause by clause.
And, Chairman, also remember that we have the submissions that may have reference to some of these clauses.
So I think we're going to go on for a very long time if we treat it with it this way. But I'm going to just close. Well, I'm going to try and end the back and forth with this particular section of the bill, and then once we move from here, we just allow Mr. Edwards to go through. But let me just hear from Senator Gale and then MP Guy. Member Guy.
Thank you, Chair. And so I raised the concern because of my notation of coming out of the last meeting with respect to clause 8, 9, and 10. And the first concern is whether or not these three particular clauses appear anywhere in any other similar type legislation. The second thing is that it speaks to now the role of the public officers. It is not clear in my mind in terms of 8, what is the level of a person who acts on behalf of the benefit of the public body. That is not so defined to me. In terms of clause 9 now, a person employed with a public body, and it went on to speak of a myriad of prohibitions. Now, it says in 3B, invest in tobacco industry or any related venture, and C, establish or operate a tobacco manufacturing, wholesale, retail, or import business. Now, the fact that you speak of employed with a public body, we can agree that that represents any employee within that public body, barring none. And so one has to define what that really represents. Now, 10.3, a person who seeks employment with a public body shall be required to make such disclosure in relation to any current or prior occupational activity or any other affiliation with the tobacco industry. So that person might be cohabiting or have a relative that is in the wholesale business with tobacco, and it may prohibit that person from becoming employed.
Member Gale,
Yes.
I think we run a risk, and no. I'll take responsibility of being sort of raggedy in terms of the examination of the bill if we jump ahead of the presentation and start to connect the dots before Mr. Edwards goes through. And remember, we have the submissions to come and so on. So
Chairman, just permit me. I was only, like everybody else, I was only representing my concern at this time, which may very well influence the thought process of Mr. Edwards when he's responding.
Right.
I was only seeking to do that.
And I appreciate that. And I do want to hear from all members on the concerns, but I'm trying to provide some structure to the approach so that we can do so in the most efficient manner. So I'm going to entertain Member Guy, given that he raised the point, but I'm going to ask members to indulge me a bit. I think it's important and would bring some order and structure to the proceedings if Mr. Edwards were allowed to go through the bill, we make our notes, we structure the presentations, and then we can query, because I'm sure these issues are going to be raised either against or for with the presentations that are to come. And that's when I think we can be more informed around some of the decisions and make a more meaningful contribution. So Member Guy, you go ahead with your
Thank you very much, Chairman. I'm glad you recognized Senator Gale before I did, because he's basically along some of the same points that I have. And not only connecting the dots between 8, 9, and 10, but also looking at clause 2, 3, which says for the purpose of this act, a conflict of interest arises when a person is employed or engaged in any occupational activity with a public body. And remember, as I said before, a public body is defined, means a ministry department of government, including statutory body or authority, a government company, and an agency designated as an executive agency under the Executive Agencies Act. And all of this ties in with what we, and I gather many other members of the committee are concerned about. So if Mr. Edwards is prepared as he goes along and when we come to that particular point to have these ironed out, I don't have a challenge. But those are my concerns right now, Chairman.
Right. No, I take the point. So what I'm going to ask then, Mr. Edwards, is for you to advance your the clause by clause and rationale for each clause, what it's intended to achieve. Place it in the context of the WHO and the sort of global benchmark standard, so that we can have that appreciation. And then let us try and complete that during this session so that we can move to a discussion along with presentations beyond today. So can you then continue, Mr. Edwards, please?
Okay, Chair. Thank you. And I fully appreciate and we welcome the interaction and the proposals and the concerns expressed. Chair and members, how we had actually started and how we propose to continue is that we had been really highlighting the changes in the law that have been implemented, that are being proposed for inclusion in the comprehensive legislation. So Article 5.3 is the first of the provisions that actually is looking at is one of the new areas that has been dealt with in the proposed comprehensive legislation, which the bill seeks to enact. So moving on from Article 5.3, we are going to just look at the fact that Articles 9 and 10, let me just, yes, Articles 9 and 10 of the SCGC require testing and measurement of contents and emissions of tobacco products and provision for the disclosure of toxic substances to the public. Provision is made in that regard, also in the bill. And then we want to look significantly at another new provision, which is the ban on advertising and promotion. Now, to some extent, our law already had restrictions on advertising and promotion of tobacco products under the Broadcasting and Radiodiffusion Act. But this now is a more comprehensive provision being included to cover all aspects of media, print, and electronic. So part 5 of the bill is dealing with the controls on tobacco advertising and promotion. Advertising and promotion is a collective term which is defined in relation to tobacco products and related products. And it means any form of commercial communication, recommendation, or action with the aim or effect or likely effect of promoting a tobacco product or relevant product. And promoting, so when we speak of promoting in this context, we're not just speaking about the ad that may appear either on television or social media. We're speaking, or on a billboard. We're speaking of activities, promotional activities, which can be done in subtle ways, which may not immediately be apparent. So promoting means the practice of fostering awareness of and positive attitudes towards a tobacco product or relevant product. I'm not going to continue verbatim, but also just to also point out that we're speaking about matters such as incentivization, distribution of products, and activities at events that may seek to sensitize the public in a way to foster positive attitudes towards the products that are the subject of the law. Lifestyle advertising is also defined because that is a concept that we use in relation to the restrictions on advertising. And that is advertising that associates a tobacco product. And I'm sure we would have all seen ads that would suggest that if you consume a particular product, it is going to result in some positive, either emotional or other type of benefit to you. So we're talking about a way of life that includes glamour, recreation, sensuality, excitement, etc. Tobacco sponsorship now is defined. And the reason we're going through these in detail is because it may help when we look at the provisions to remember that these are the definitions that apply in relation to advertising and promotional activities. Tobacco sponsorship means any form of contribution to any event, activity, organization, or individual that has the aim, effect, or likely effect of promoting a tobacco product. And this can apply in what we speak of as corporate activities, corporate social responsibility activities, which on the face of it appear and may have a useful benefit to individuals or organizations, but they are also of particular benefit to the industry in promoting, whether directly or indirectly, a tobacco product or relevant product, or the manufacturer or seller of the product, or the use of the product itself. So we are focusing, as I said before, on the new areas that the bill has is seeking to cover. And one of these new areas is making provision for reducing tobacco dependence. So it's one thing to speak of reducing demand or reducing or interfering with the supply chain or being involved in regulating the supply of tobacco. But the FCTC also obliges parties to implement provisions that will support reducing tobacco dependence. And if we look at the clause 3 of the bill, we will see that clause 3B puts as one of the objects of the act, not just the ensuring of compliance with the convention by control activities, but also to protect persons who, this is 3B on page 9 of the bill, protect persons who consume tobacco products or relevant products from the inducements to use the product. There are many persons who, although they use, do not use happily or willingly. And therefore, the FCTC seeks to require parties to implement measures to facilitate and induce persons who wish to be separated from or to reduce their dependence on these products to have opportunities to do so. So states parties are urged to create such opportunities in their public health arrangements. And then furthermore, clause 5 of the bill, page 11, obliges the minister to seek to implement measures in relation to encouraging demand reduction, and this is in 5B, clause 5B, to encourage demand reduction measures involving the development of a national tobacco cessation strategy, as well as disseminating tobacco dependence treatment guidelines through a comprehensive nationwide education and information campaign. So this focuses directly on the public health concerns that are relevant in relation to tobacco use. The protection of children, something that had been mentioned earlier by Member Guy. Article 16 of the FCTC is prohibition of sales of tobacco products to persons underage, so to speak, and this is in the context of domestic law. So our domestic law speaks to children being persons under the age of 18. Already provision is made in the Child Care and Protection Act, Section 40, for such prohibition and protection. And then we have implemented at clauses 15 and 16 of the bill, which I would refer members to at page 20 onwards. This seeks to go beyond what the CCPA at section 40 had started in terms of protection of the children and young persons. In that, firstly, clause 15 prohibits the supply of a tobacco product or a product to a child, meaning a person under the age of 18 years. And also there's a restriction on the supply of ENDS, the electronic non-nicotine delivery system to a child. So in clause 15, we will see the further provisions made in relation to sale and management of sale and notifying members of the public that it is illegal to sell or offer to sell these products to children. Now, in the provision at clause 16, there is the prohibition on a person using or causing a child to be used to supply tobacco products or to operate as a courier in relation to tobacco products. And we know that this is going to be something that at the community level will have to be very carefully dealt with because of our community practices. But these are some of the provisions that the bill is seeking to implement for the purposes of protection of children. So that actually is the end of the presentation, because we had covered on the first occasion most of the provisions. So when we get to the point of the detailed examination of the bill, we will be able to, and in the context of the submissions that have already been received, we will be able to elaborate on some of the matters of concern. But this presentation was really an overview seeking to address the broad themes that the bill proposes to cover. Thank you.
Okay, thank you very much, Mr. Edwards. Edwards, with those, the presentation you made and the areas you touched on, would those be considered the sort of more controversial elements of the bill? And in that regard, are these elements that are likely to generate more discussion? Are they, how much of a deviation are any of those from this sort of global benchmark, which in other words, are we breaking new ground with any of these clauses?
I wouldn't say we're breaking, and I'm going to be supported by my colleague Cheryl Dennis Wright in this. The extent to which we're breaking new ground would largely be from a regional perspective, not necessarily from an international perspective, because there are states, I dare say, that have gone much farther than we are even proposing to go now with this comprehensive legislation. But within the Caribbean region, we definitely only have Mrs. Dennis, right?
Guyana.
Just
Guyana. Right.
Really?
So we're not, so on that point, we are not at all breaking new grounds. And in fact, our counterparts in Guyana would have been the first in putting forward some of these, in fact, a comprehensive tobacco control legislation that really takes into account the provisions of the treaty as well as the guidelines for that implementation. But certainly globally, we are among
We're
several
leading.
other
We're
countries,
leading. Yeah.
right, that have led in this regard. And on the point of the guidelines, even though some of the provisions like Article 5.3 are not mandatory in the way that the Framework Convention has framed it, we are certainly encouraged by the Convention Secretariat. And when parties such as Jamaica attend the COPs and they make decisions, we are certainly bound, or we would have signaled our intention to be bound by those decisions at the COP. And therefore, these guidelines in that regard would be binding on us.
But if I may add to what Mrs. Dennis Wright has just said, chair and members and colleagues. Yes, we may say diplomatically that we are not bound, but in a sense, the convention really does require member states to, as far as possible, implement the terms, and in some respects allows or encourages them to go beyond. In other words, the convention, the FCTC, is the baseline, but is not the end game. Their states are encouraged to, even if they so desire, to go beyond within the framework of their law and constitution, of course. But I dare say we are not being radical but we nevertheless note the concerns and the desirability of ensuring that language is framed in a way to avoid ambiguity.
All right. Thank you, Mr. Edwards. Let me I see some hands up and I'll recognize you. I think this is an appropriate time to get some feedback, but let me ask first, are there any other elements of the bill not mentioned any colleague would like some elaboration on from the legal team? Mr. Edwards attempted to go through selected areas. Is there any other area that you think may require some elaboration or at least explanation?
Chair, if I may, I actually touched on all the articles that are sought to be implemented. So it's not just the controversial areas. It may be that all the areas have some element of controversy, but we didn't really just select the more controversial areas. We sought to just touch on all the areas now covered, now proposed to be covered by the comprehensive legislation.
Chairman.
Chair, I think your mic is muted.
Chairman.
I was saying that are there any points that were not raised that anyone would want to raise? If not, I'll go in the order as outlined. Member Guy, Gail, Allen, Morris, and then Longmore. Starting with Member Guy.
Thank you very much, Chairman. Just there are many other points, but as we have agreed first that we'll look at them when it comes clause by clause. But just one main point here, and I recognize, Mr. Edwards, that your team looked at different different jurisdictions and got different pointers as to how to do the legal drafting. But could I suggest to you that there's a consistency in terms of, if you look at clause 13 and clause 15, one you have metric and then the other one you have inches and so you need to have your team look at that and standardize it. Secondly, as it relates to the signs in the buses, and probably I'm going a little too far in terms of what we're looking at, but it is just a 3-inch by 8-inch sign, a warning about dangers to smoking. And Minister, I think, Chairman, I think that is quite too small a sign that we should be having in these buses. 3 inches by 8 inches, really something that is not very visible, you know? So could have your team.
All right, we make a note of that.
Noted, Senator Guy. And the point of the metric is that it's something that in our checklist we had gone through. So that if we had anything that slipped us, thank you for raising it.
Okay.
If I may,
yes,
if I may, Minister, in relation to the size, there is a provision that says that there is nothing in these regulations which prohibits anyone from increasing the warnings as it relates to the no smoking signs. So that provision is there in relation to signs that are put up for no smoking.
I guess the issue is what would be a sort of minimum requirement.
Minimum, yes.
If the minimum is not sufficient, then we could up the minimum, as we are doing with the packaging. So that's worthy of note, I think.
Yes,
Member Gale, your contribution.
Thank you, Chair. Thank you. And Chair, I'm starting from the aspect of the convention where we would have signed in 2003 and ratified in 2005. And there is always the need for us to align our legislation to convention. Now, in terms of these particular areas that are more sensitive in the legislation, the areas that relates to conflict of interest, I remember asking the question where in our jurisdiction or any other jurisdiction, there would have been a legislation that we are aligned to. And Ms. Dennis Wright had indicated the Guyanese legislation. And it would be helpful if we could somehow have an appreciation as to being privy to that legislation where we can have the comfort and confidence of the alignment. Because what that does, Chair, is that it allows for the transparency of the process and for us to better understand the process. And also for us to appreciate the connection between the convention and these aspects of the legislation that may appear somewhat controversial. So in the course of these deliberations, if the committee could be privy to that type of information, it would certainly be helpful. Thank you, Chair.
Thank you very much, Member Gale. I think that's a good point. Senator Allen, Member Allen.
Thank you very much, Mr. Chair, and Mr. Edwards for going through the proposed amendments. I just want to make an observation, and it was especially at the point when Mr. Edwards, you were going through the various sections, particularly to do with advertising, promotion, and the intended restrictions that would be applied. And it almost, I know from the Ministry of Health's point of view, that is very important in terms of the trying to prevent smoking or to reduce smoking or to have it none at all, as a matter of fact. But then the issue is balancing that against the other reality of the business of that is being engaged in tobacco, which contributes in terms of taxes, which contributes in terms of contribution to the NHF and so on. And so it causes me to sort of caution us, how do we make sure that we balance it, achieving the objectives of the Ministry of Health and obviously or signing on to this convention, but at the same time not strangling the industry that does have its right within the economy, you know. So it's I wonder to what extent or how far do we go that it does not prevent the business from continuing and therefore then cause for the illicit trade to grow. So it's just a conversation we could have around that. Not necessarily, I don't have a question in there anywhere. It's just an
let me just say that is an argument that is advanced by the tobacco industry, oftentimes as part of their defense for preserving some of the efforts at convincing consumption and influencing consumption. Public health's position is very clear, and it's not unique to us here in Jamaica. It's global, that the tobacco industry represents a clear and present danger to public health, that it is perhaps one of the most extreme, if not the most extreme, in terms of its negative impact. In other words, there is no sort of middle ground per se. It therefore, from a public health perspective, has to be very clear and about the ill effects and the approach to discouraging consumption rather than to preserve any market advantage or market opportunity. So it is a challenging position to be in, because there is perhaps no middle ground there. Having said that, it is a legal industry and allowed to operate, but public health has always been and has to continue to outline the ill effects and the consequences of consumption of tobacco. And I think that's what the legislation is aiming to do, to ensure that consumers are fully appreciative of the information, and to ensure that we, in fact, to be very blunt, discourage consumption of tobacco products as best as possible. And I think that has to be how the legislation is viewed.
Oh no,
Chair?
I totally understand and appreciate that. Of course, we all are aware of the effects of smoking and what it can cause. I guess it's, and of course you will have those who are proponents of the industry who will come and make their presentations. It's just, like you said, finding that middle ground, which it's almost as if there's hardly ever a middle ground on this type of subject, you know.
It's a challenge, yes.
Sure.
All right, may I hear from Member Morris? Your hand is up, Member Morris.
Here, I think Mr. Edwards wanted to make an intervention, but my point was it was sort of related to Senator Allen's point of finding that middle ground. And when I looked at section 24, I believe, which speaks to sponsorship, you know, I was a bit caught up by it, because I was looking at, yes, the challenges that we're facing with wanting to cut back on tobacco consumption, but then I also looked at the social benefits that sometimes come from these companies, for example, scholarships, and I wondered how we would treat with that. So that was a concern for me, like Member Allen, you know, finding that middle ground between the benefits and the risk. Another thing that jumped out at me, and I would like Mr. Edwards to probably provide some clarification, is how we would treat with cessation intervention. Would there be access to cessation services that are provided by the ministry? I just wanted some clarification on that matter. Thank you.
Chair, may I respond?
Yeah, go ahead, and then I will come in after.
Okay, so the second point in relation to cessation, what the bill proposes is a framework. So it proposes that guidelines may be developed in this regard. So it doesn't create any elaborate provision for the cessation measures and approaches. It merely provides the framework for guidelines and policy, etc., to be developed. And I'm sure the Honorable Minister can elaborate on that, as well as those who are more qualified than myself in the area of control of use. So there is just a basic framework provision in the bill on which to build the development of guidelines and other approaches to cessation and dependence. No,
Okay. Go ahead. Sorry.
Now, in relation to the matters raised by Senator Allen and Senator Marsh relating to the ban on advertising, I just wanted to share something with the meeting. If I may just share my screen very briefly. And this is this is a website that we can find tobacco control laws. Campaign for Tobacco Free Kids is an organization, international organization, that primarily seeks to protect the interests of young people in terms of health, protect them in relation to warnings and noting the controls that are desired on tobacco in the interest of public health, especially in the context of younger persons. And I just wanted to point out that what we're seeing here is a listing of countries that have actually banned advertising tobacco industry sponsorship of events. So these are countries around the world that have to some extent restricted or prohibited in total the sponsorship by tobacco industry of events, activities, individuals, and organizations. So it's a range of countries. And I think we will probably notice a significant number of countries in the developing world that fall within this category. So we'll see South America represented, Argentina, Azerbaijan, Benin, Burkina Faso. So we see Africa, we see the Caribbean, Costa Rica, again, several African countries, Cote d'Ivoire, Djibouti, El Salvador. Some for France, Guyana, as has been mentioned before, Malaysia, Mauritius, Mongolia, Nepal, Norway, Panama, Russia, Spain, Suriname. So we're seeing a range of countries. And by the way, this website indicates in relation to a number of the areas that we're looking at in the bill, indicates the countries that have implemented to either fully or to some extent some of the areas that are covered in our comprehensive legislation. So when we go through in a more detailed way, we can actually highlight in a similar way the specific countries that have implemented particular aspects of what is being proposed by this legislation. But I just thought that since we were having the discussion on advertising, promotion, and sponsorship, that I should indicate that it's something that has been addressed by a number of other countries around the world. Thank you.
I think there's going to be a better appreciation, members, for the context of the legislation once we get into some of the presentations that will come after today. And I crave your patience and indulgence to allow that process outside of what you will do in your own time by way of your own personal research. The tobacco industry, this particular industry has sufficient historical data globally, whether from a public health perspective, from a regulatory perspective, from an advocacy perspective. And what is going to be very important for us as a committee with an awesome responsibility to manage a process through to legislation is that we inform ourselves as best as possible on what is happening and why elements of this legislation is there and question it, sure, but I think the information and the context is important. But I think a lot of that is going to come out. Once we complete this, I'm going to just list or propose a list of the first 3 or 4 presenters based on submissions that have been placed before us, so that come next meeting, we can begin to appreciate more some of the other perspectives. But let me just quickly now go to Member Longmore and then to Member Campbell. Member Longmore.
Thank you, Chair. Through you, Mr. Edwards, with respect to Part 5 of the bill, tobacco smoke-free environment, what specifically was the basis for the distance references, the 5 meters and the 10 meters? I have other issues that we will discuss later around that, but I'm trying to ascertain what was the basis for determining those distances.
Okay,
that's one. Oh, well, I have a second concern, but you can.
Please continue, Senator.
And the second concern on page 10 of the handout that we were given, where it refers to the core non-price demand reduction, 3 of the 7 core principles for the demand reduction by the FCTC. What of the other 4? What I'm wondering is whether or not we are in full compliance, so to speak, or we are following and implementing all the comprehensive tobacco control legislation that incorporates all of the FCTC recommendations, because here I see 3 of 7. And if we are not, what might be the outstanding ones that we're not included? Thank you.
Okay, thank you, Senator. So in relation to let me answer the second one first. In relation to the implementation, these 3 were the ones that had been, the 3 referred to are 8, 10, and 11, Articles 8, 10, and 11 on the demand reduction. Those are the ones that were originally implemented by the Public Health Tobacco Control Regulation, which all members are aware of. And what the bill is seeking to do is to build on that framework. So we have those 3, Article 8, 10, and 11. And the bill is essentially implementing all the other, 7 other areas now are being sought to be implemented by the comprehensive legislation, which is why it's called comprehensive. So we moved from just the original 3, added 7 more. The only area that is not being implemented right now under the legislation and is dealt with in other areas of public policy is the area of demand reduction relating to financial and taxation measures. But every other area is being sought to be covered now in this proposed comprehensive legislation. Senator Long will remind me of the first question.
The determination of the distance.
Oh, the distance. I'm going to ask my colleague, Mrs. Dennis Wright, to handle that. Thank you.
Okay.
Right. So in terms of the distance, we would have been guided by the guidelines of the implementation of Article 8. And that also is scientifically based, because there was a look or an examination as to exposure in terms of the distance and where people would have more likely been exposed based on particular distance. Again, based on what Mr. Edwards has just to reiterate what he just mentioned, this is not a new provision, but these were also provided for in the 2013 regulations. And as I mentioned, the guidelines would have provided for certain distances in terms of, countries would have the latitude to regulate within their own or having regard to their own constitutional safeguards. But these were also scientifically based. And other countries would have enacted similar legislation.
And when we get there, because there's a discrepancy where a different distance is used in a different reference. And so we will probably get into more discussion at that point in time. But thank you for that clarification.
You're welcome.
Thank you, Chair.
Okay, thank you. Senator Campbell, you want to go ahead now, please?
Yes, thank you, Chair. I have a question about South Side. Minister shall seek to implement measures to, and it outlines 3 areas. And I see also at clause 7, the public health policy provisions determining what the public health policy of the government should provide for. And just as a matter of what we're capturing in this, when we insert a provision like this, and I'm assuming that the Ministry of Health has embarked on looking at strategies for demand reduction and public health awareness and so on and so forth. But is it typical that we capture this in the legislation? Because as a member of the public, the question that I would that would arise from me in this is, if the minister does not implement these measures or doesn't seek to implement these measures, and if the public health policy of the government does not provide for these things, how do I hold the minister or the government accountable? Are there criminal sanctions for the minister and the government under this? What are the sanctions? I'm just trying to understand why we would have placed that here, because the implementation or the development of policy and strategies would be the normal function of the ministry anyway, and the purview of the executive in any regard. So can you just explain that for me, Mr. Edwards? Thank you.
And Senator Golden Campbell, I can't say that we did not anticipate this question. The intention really is largely to send a signal in that, yes, we know that the portfolio responsibilities will provide for the subjects and areas of policy to be covered by each minister and by extension ministry. However, it was felt that, especially in this area of significant reform, that it was important to send a signal by obliging, of course, not with criminal sanctions, but there would be other types of expectations, putting an obligation on the minister to seek to. So we note how it is worded. It's an obligation for the minister to seek to implement measures. It's not an obligation on the minister to implement. And therefore, it is a question of putting it in the mind of the minister and the policymakers, these specific topic areas for focus within the legislation itself. The legislation, it's almost like an objects clause. I mean, you don't really hold a minister or a government to the provisions of an objects clause, except for the fact that they do help with the interpretation of the law. So that from a strictly legal legislative philosophical perspective, by putting in a provision like this, where you seek to, where you oblige a minister to seek to implement these categories of measures, then you're also helping to frame the context of the law so that it may, at some point, help to clarify any ambiguities as to where the minister or the ministry should be going. So that is the main reason why 5 was worded that way. And then 7, which is not a common provision to have, where you actually speak to the policy to be implemented. But again, it was felt that in such an area of significant public health reform, it was important for a statement to be made that the policy intention should cover these areas. And of course, the policy intention in relation to tobacco control doesn't all have to be stated in a tobacco control bill. But it was felt that it was important, especially because a significant part of the obligations in relation to the FTCT and member states lies with the safeguarding of policy. So this legislation is unusual in that regard, in that it is specifically looking at the securing the integrity of public health policy. So those
Can I just give a little additional context, Mr. Edwards, because my concern about it is this: having signed the convention, I'm assuming that we had it's sort of treaty-like, yes. So we would have signed onto it, and that, in my view, is what obliges the government to undertake the policy development measures that are required to implement these kinds of measures.
Yeah.
My concern about it, in stating it this way, as opposed to including it as an object clause, is I'm a little uncomfortable with us legislators placing into a law a requirement on the executive that touches and concerns their purview. And while I understand the purpose of it, to frame our minds and all of that, I am uncomfortable with the lack of separation that I think it causes. I don't have a difficulty with the intent of it and the policy intent that we're seeking to place in our minds. But I have a difficulty as a legislator telling the executive, look, the policy that you develop must have this, must have that. That's really the purview of the executive, and I'm not comfortable with us putting it like this. Because at the end of the day, we're not really obliging them, if that's what you're saying, because there's no sanction for them if they fail to do so. What sanction is there? None. So in my mind, it really ought to belong more in a sort of object memorandum type of provision that I would think would probably come at the beginning or end of the bill. And I'm not sure where you place it. But that's my discomfort with it.
Okay, well, I'll be very brief. And through the chair, there is the objects clause appears at clause 3 of the bill. So it's something to be considered. If the committee members have particular disquiet with it, then the objects clause may be modified further to address these public health policy issues. But the idea was that, and the sanction, and I know Senator Golden Campbell appreciates that, the fact that there isn't an apparent or express criminal sanction doesn't reduce the usefulness of having a provision in the law like this. But and the fact that it seeks to provide directions as to the actions of the executive, again, that, in my view, is not a direct conflict in terms of separation of powers, and because the law always, in many cases, seeks to indicate how the powers of the executive should be exercised. So, but as I said, if there's a difficulty that the committee feels should be addressed, then we, of course, will take it under advisement and consider whether another approach can be made. Thank you.
And then just note that point for me, and we can review and get back to it at an appropriate time. All right, so members, I wanted to, if we're completing this session, we need to wind down shortly. Wanted to move to the next item on the agenda.
And before you do, please.
Yes, member guy.
Thank you. Chairman, I just want to put it on the record that I am endorsing what Senator Campbell mentioned a while ago as it relates to clause 7. And, I'm wondering whether this should really be part of the bill that we're really debating here now, but then, as you say, that can be looked at. And as Mr. Edwards said, it's the committee's decision. When we get there, it is something that can be rectified, but just put it on record.
Okay, thank you very much. All right, so members, I want to thank you for traveling to this point. I want to just go quickly into the next item, which deals with of the presentations.
But you're the one who traveled, Minister.
Sorry?
You forgot you're the one who traveled.
All right, a manner of speaking. We need now, I want to thank Mr. Edwards and Ms. Dennis for taking us through aspects of the bill, and for my colleagues, and to my colleagues for the comments made. And I think we need now to move towards the scheduling of the presentations, the oral presentations by stakeholders. Up to this point, I have 15 submissions, not all interested in presenting. I want to propose 5 in order of start to finish for the agreement of the committee. I want to propose firstly, the Heart Foundation of Jamaica, then the National Council on Drug Abuse, then Carreras Limited, then the Jamaica Manufacturers and Exporters Association, and then the 5th would be the Coalition for Tobacco Control and Healthy Caribbean Coalition. I want to propose in that order those initial 5, and then we can add to that as we go along. And I'm proposing that we take, do you think we can take 2 per sitting, per session? That should be reasonable. What do you think?
Chairman, I think the first 2 we could take at one session. I suspect that being the only tobacco manufacturing company or entity that has responded to the request, that they may come armed with a lot of things. So I think we should have one session for them.
Okay.
And then the
other 2 after.
One session,
so,
right.
So we look at the next 3 sessions to complete 5 presentations, and then after which we will add as we go along. Is there any comments on that approach?
Chair, as a point of clarity, did we not agree a time limit on the presentation? Do I recall?
Well, it's not. Yeah, it's not a presentation so much as the question and answers that will, I think, take up most of the time. Right. But we can finalize on a time limit. We could say 20 minutes maybe. Is that too much? The real length of time is likely to be the discussions after.
I would have suggested 15, Chair.
15, you said?
I would have suggested that if they're going to take the presentation, and certainly allow them to do the presentation and then do questions after, then I think 15 minutes is a lot of presentation.
All right. So can we agree then to a 15-minute presentation, and then for discussion, we do the first 2, the Heart Foundation and the Council of Drug Abuse first, next sitting. Then we go to Carreras the sitting after, and then the Manufacturers Association, the coalition after. Are all agreed to that? So moved?
Yes.
Okay, yes. Great. I see no objection.
And Chair, if perhaps the Parliament could give some guidance, because 15 minutes really contemplates that the presenter is going to highlight the important points in their already submitted presentation. Not that they're going to come before the committee to read the entire presentation. And I think that guidance can be given.
And I assure you, Member Campbell, that I would not allow that, because like you, I believe that we need to keep within a time, and beyond 2 hours, I think diminishing returns starts to setting. So I'm with you on that, and I will, if the Parliament can allow for some guidance there, we would appreciate that. But I will certainly assist in providing that guidance. All right, so I think we're agreed on that. And
Chair, yeah.
Yes.
Just a question. Is there a matrix in contemplation? Is there preparation of a matrix that will actually show comparatively the types of comments and the matters commented on by these different bodies? Is a matrix being prepared by the parliamentary staff?
I was under the impression that your team would have done that, Mr. Edwards. I thought you had said that in the early stages of this committee. Am I incorrect?
I think he referred to matrix
there
in the
needs to
bill.
be.
I recall mentioning the matrix, but I don't recall taking ownership.
But chair, the matrix is usually prepared as we go, as the submission go along.
Yes.
What would have been taken out of the submissions would form the matrix. And then when we review the matrix, we'd be going through what those recommendations are.
Right. So Mr. Edwards, we need to have a conversation with Ms. Dennis and maybe with Yanni here in my office to ensure that that matrix is produced. I was under the impression,
and Ms. Brandon.
Yes, I was under the impression that it was being done. So I am happy that you have raised it. So let us be clear on it. That yes, one needs to be done. Okay. So Ms. Dennis, right? I'm going to ask you to do some follow. And let's arrange for that to be put in place.
Yes,
all right.
We'll do,
Chair,
yes, Member Campbell.
Chair, can I just ask you to repeat the last submission that you were saying?
Right. So the last one would have been the coalition, the coalition for tobacco control and healthy Caribbean coalition.
Okay, thank you.
Yeah.
Chair, can I just ask you to just repeat the first two, please?
Right. So the first two would be the Heart Foundation of Jamaica and the National Council on Drug Abuse. The next one would be Carreras Limited. And the last two would be the Jamaica Manufacturers Association and Exporters Association and the Coalition for Tobacco Control and Healthy Caribbean Coalition. And
Thank you for that. Thank you for that extensive list, Chair.
And that we anticipate will last over 3 sessions, the next 3 sessions. And we'll work out the logistics of time, 15 minutes presentation, then we go into answers and comments and so on. And then the matrix, Mr. Edwards and Ms. Dennis Wright will work on. All right, any other business?
Sorry, Minister, I'm seeing where Ms. Brandon has indicated in the chat that a matrix will be prepared, but we'll definitely follow up.
Please follow up on that. That's very, very important.
We'll do, Minister. And I was wondering, I know that Heart Foundation is a part of JCTC. So you're indicating, because I'm here making notes, you're indicating that Heart Foundation will be doing a separate presentation?
They did a separate submission, and I think it will be useful to hear from them separately. Okay, any other business? Any other business? No? Going once, going twice?
Sorry, did we agree on the next meeting, Chair?
Well, that would come next after any other business.
Oh, sorry.
If there's no other business, then can we decide on a date for the next meeting? Can I get some help from the Parliament on any proposed date, please? No calendar there. Is our parliamentary support team online? Not hearing or not seeing. Okay, April 29th at 10. Is everyone okay with April 29th at 10 a.m.? Any objections there?
Are we meeting in this format again, going forward, Chair?
I really would prefer face-to-face, but I see Senator Campbell in her mask.
Online.
We don't know
and would it be at 10 or at 9?
At 9 is good.
10, we have 10 there. 10? We 10 to 12 is I think a good time, if that's fine with us all. I'm prepared to go with that. We could continue online until the rest of us, or there's some advocacy for a change back to our original, to the Parliament.
Or perhaps we can start at 9:30, somewhere in between. I mean, maybe get the most out of the morning. 9:30.
9:30 is fine for me. or 10. So if members say 9:30, we go for 9:30. 9:30?
9:30.
Okay. So are we going to do as online Zoom next session and then decide from there, or?
Let's try that. And then we will determine after that, Chairman.
So we go with the Zoom and then we go from there.
Yeah.
All right, sure. Okay, great. All right, so I think that's it for us.
Excuse me, Chairman, I'm so sorry to interrupt. Marlene Aldred. Just
Hi.
as it, if you don't mind, just as it relates to the request to have physical meetings, please note that some of us still are not vaccinated. And so it is at greater risk for some of us to have to do physical meetings. And I'm speaking, I think, on behalf of most, if not all, of the technical team.
I am rooting for all workers to be vaccinated.
And I appreciate the pressure you have just put me under, SG. And we're working on it. We're working on it. So
Parliament needs to function.
We will hopefully on the 29th we can give a better update, and I think we're in a better position to decide on the way forward. Thank you very much. So thank you, colleagues, members. Thanks to the parliamentary staff, to the legal team. I think we've made some progress. It's quite clear that there's a lot to discuss, and we look forward to the presentations from the submissions that we have received today. Thank you, and have a good rest of the day and week. Thank you.
Everyone, keep safe. Keep safe.
All the best. Keep safe.
All right, colleagues.
Bye.
Thank you, Chair.